I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about legal word pairs and a linguistic concept called the Hendiadys and interpreting statutes. Here we're looking at some of the distinctive features of legal language in terms of the words and phrases we use as opposed to the structural features that we usually talk about when we're discussing the canons of construction. Now, why is legal language so different than everyday conversational English? Well, there's a few reasons. First, courts and legislatures are institutions that really value tradition and formality. So they produce legal texts that tend to use a lot of formal language or outdated or archaic language. Also, lawyers and judges like precision. They don't want to use a word that might be misunderstood in a way that they haven't foreseen. So obscure words that aren't used that often, tend to have fewer possible meanings than the words that we use the most frequently in everyday speech, which could have a lot of different meanings depending on context. So lawyers and judges tend to use more obscure words in their quest for precision. But there's also something else that happens in legal English, and that's the prevalence of a lot of word pairs or couplets. And these are phrases like aid and abet, will and testament, bequeath and devise, that almost always occur together in the same order, and they have a single meaning. Linguists have a special term for this, a technical term. It's called a Hendiadys, which is one meaning expressed through two words. And I just gave some examples, and we're going to talk about this later, about why this occurs so often in legal language. The main point, though, is it would be a mistake from an interpretive standpoint to try to ascribe a distinct or separate meaning to each of the words in a Hendiadys. It's a couplet that has a single meaning, that functions linguistically as a single word. We're also, near the end of this video, going to talk about a special type of gerund from archaic Norman French infinitives that make up some of our odd-sounding English legal language terms. So the very fact that we have a lot of holdover words from Anglo-Saxon times explains some of the unusual words that we have in our legal lexicon. In conversational English, we don't use words like bequeath and deem and theft quite as often as we do as lawyers or in legal texts. And these are words that are holdovers from almost like fossils from the Anglo-Saxon period that stuck around in our language even when the rest of the language really changed and evolved a lot, especially our grammar. Okay, most importantly, though, from this Old English period or Anglo-Saxon period are these alliterative pairs, which before the period when most people could read and write would really help people remember or memorize the laws and the legal decisions. So aid and abet, clear and convincing, have and hold, part and parcel. And it would be a mistake to try to figure out what abet means, separate and distinct from aid. It was supposed to be redundant and lyrical to aid with memorization. So when you see a word pair or couplet in legal text that occurs a lot and both words start with the same letter, it's probably like a verbal fossil or vestige from the Anglo-Saxon period of our language. Now, the biggest change in the history of the English language happened after the Norman conquest. You might remember the Battle of Hastings in 1066, which brought French-speaking royalty and rulers to England, but they were governing peasants who spoke Anglo-Saxon. And this meant that legal texts needed to have the important words or operative terms in both Anglo-Saxon and Norman French. And this led to more legal pairings like bequeath and devise, breaking and entering. In fact, I have a list for you of some samples that should look familiar to law students. Devise and bequeath, breaking and entering, acknowledge and confess, will and testament, free and clear. Those sound familiar. I have the Anglo-Saxon word here in italics. The Norman French word is in non-italics. Norman French, of course, is ultimately a Latin root word, typically. And again, it would be a mistake when you're interpreting a statute to try to ascertain some unique meaning for bequeath that's different from devise. The whole phrase linguistically is supposed to be a single idea or a single verbal unit or almost a word, Hendiadys. Now, Law of French, which came in the Middle Ages as a holdover from the Norman French period when the rulers were speaking Norman French, left us with another set of word pairs, and these are ones where the adjective follows the noun. In some languages, like French, the adjective can come after the noun. In English, we usually put the adjective before the noun, like the green books behind me. But look at these phrases. Now, before you went to law school, you might have said the word accounts, or attorney, or condition, or you knew what a fee was. But when we put an adjective after it like this, it takes on a specific meaning. Accounts payable, attorney general, condition precedent, fee simple, letters patent, malice aforethought. So these became legal terms of art, and the pair is a holdover from Norman French, where the adjective would come after the noun. The exception to this rule, it's almost a rule on its own, is that the adjectives in Norman French that referred to size would come before, hence grand jury versus petit jury, and so on. Okay, we're almost done. Law French also left us with these funny gerunds. What is a gerund? A gerund, and we have gerunds in modern English, a gerund is a noun that describes an action. So we normally, you would think the verb is the action part of a sentence, but sometimes we use a noun to describe the verb. And in modern English, we would normally do this with either the infinitive of the verb or the participle. I don't want to give a big grammar lesson here, but if you look at the words on my list as an example, we would normally talk about to join or joining as opposed to joinder. We might use a word like to merge or merging instead of merger. But in the legal system, in legal language, we use these words. Why? Well, in Norman French, you made the infinitive, instead of putting to before the word like we do in modern English, you would put an ER suffix on the end of the word. Or in a few rare cases, ALs, and that gives us a set of Norman French gerunds like acquittal, denial, proposal, rebuttal, and trial. And so lawyers and judges and legislatures continue to use these kind of archaic forms of the words because they evoke the sense of all of the legal doctrines and rules that surround this concept. So we could talk about merging or to merge, but when you say merger, it implies either the doctrine from criminal law that lesser included offenses merge into the most serious charge against the defendant, or maybe the idea of two incorporations of two distinct legal entities becoming a single corporate person or a single legal entity. And so that's a merger. It's not just two companies merging. It would still be grammatically correct to say they're merging, but when you talk about the merger, it has more legal connotations, and the same with ouster and remainder, sequester, and waiver. Okay, here's a review question to see if you've been paying attention. If a certain pair of words frequently recurs in the same order in legal texts, though each word sometimes occurs separately, how should a court construe the word pair? A, the court should ascribe a distinct meaning to each word in a statute, or B, the court should recognize a Hendiadys when it occurs and ascribe a single meaning to the entire phrase. Now that's supposed to be an easy question. If you're not sure, you should probably rewatch this video. And that concludes our lecture about word pairs and legal English.